Good day, Crime Talk aficionados. My name is Scott Reisch. Thanks for watching Crime Talk. First on the docket, an analysis of what to expect when the motions are filed in the Daybell-Vallow and Chad Daybell case. Second, LA County deputies are ambushed. Third, two very disturbing cases that go into the you just can't make this stuff up category. Fourth, wrongfully imprisoned, now a practicing defense attorney. We have a cold case for you today, our winner from the Dumb Criminal Contestant of the Week, as well as our new contestant. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk. Thanks for watching. If you haven't done so already, we'd ask that you hit that subscribe button, hit that little bell so that you receive notifications of when we go live or put up new content. And as always, leave us a description below. And just a reminder, tomorrow is Tuesday, so we will be going live at 6 p.m. Mountain Time on both Facebook and YouTube. And then after that, immediately following that, our Patreon members will have a one-on-one conversation, so make sure you subscribe to our Patreon members. First on the docket, the Daybell-Vallow Chad Daybell matters. As we all know, Daybell-Vallow appeared for her arraignment last week, and now the matters are set. Now, let's take a look. If you take a look at Daybell-Vallow's trial setting order, her trial is scheduled to commence on March 22nd, and then it goes through the 26th, resumes again on the 29th, 30th, for a total of 10 days. If you take a look at the order for Chad Daybell's trial, you see that the trial schedule begins on January 11th, 2021, and continues through January 29th, 2021. That is some 13 days. Obviously, the district attorney thinks that if these matters are separate, that they won't need as much time. First trial always takes a little bit longer, but by the second time, it will in fact go much smoother because you know what the witnesses are going to say. They know what they're going to say. The witnesses aren't that intimidated about going to court. And frankly, you've had a dry run at it. Now, this issue still remains, will there be a motion for joinder granted where a joint trial will be held with both Daybell-Vallow and Chad Daybell? And I told you last week, the reason for not having a joint trial for these two, cited by Mark Pryor, Chad Daybell's attorney, is founded nowhere in law whatsoever. Although he can say, well, it's going to be more press if there's one trial versus two. I think there's going to be plenty of press whether there's one trial or two. The reality of it is that he cited no reason not to have a joint trial. He may be hard-pressed, but we shall see, because also what is interesting in the court orders for both Chad Daybell and Daybell-Vallow is that all of their motions are due 28 days from the date of arraignment. So what does that mean? We know that based upon the date of arraignment, Chad Daybell's motions should be due about September 21st. And since we know Daybell-Vallow's date was just last week, her pretrial motions are going to be due roughly about October 8th. Why is that significant? That is truly going to show us what evidence the defense doesn't think should come in, whether it was obtained illegally. It's irrelevant. There's going to be pretrial motions to try and keep that evidence out. It's going to let us know, as the observing public, what is their true trial strategy. Is it Alex Cox is the one that did it, and we had no idea, and oh my gosh, we were duped by Alex Cox? I think that's kind of my leading theory that I would go on as someone who's practiced law for some 25 years. Never hurts when you can blame the dead guy. Why? Because dead guys don't talk back and cannot profess their innocence. Don't see each other pointing the fingers at each other as long as you've got somebody that can say Alex did it, or at least raise the inference that Alex did it. Remember, ladies and gentlemen, the defense does not have to prove their client's innocence. The prosecution always bears that burden to prove each and every element of the offenses charged beyond a reasonable doubt unanimously to a jury of 12 people. The defense is going to be able to argue any reasonable inferences drawn from the evidence or lack thereof. And guess what? A lot of stuff with Alex Cox. And guess what? Alex Cox won't be there to defend himself. Expect that to be flushed out when it comes to the motions hearing. And that's when things are really going to get good. Next on the docket, 2 LA County sheriffs ambushed. Now, ladies and gentlemen, that is all that you can call this. There is no defense to walking up to 2 police officers sitting in a car and engaging in fire at them, striking both of them in the head. Now, the LA County Sheriff's Department has offered a $100,000 reward, leading to the arrest of the individual responsible for this conduct. And let's face it, ladies and gentlemen, there is a lot of debate out there whether the police should be defunded or actually given more money and better training. But I assure you, walking up to police officers and shooting them in the head while they sit in their patrol car advances no one's cause whatsoever. That is just plain attempted murder. And fortunately for the officers, looks like they're going to survive. They're probably going to have injuries. We know one of the deputies is a 31-year-old mother, and the other is a 24-year-old man. They were both fighting for their lives, but it looks as though they're going to make it. Both deputies had only been on the job for 14 months. And there's video. We're not going to show you the video because YouTube will shut us down on the monetization, but you get the gist from the stills that we're showing you here. Somebody walks up and then shoots and then walks along acting as if nothing has happened. Well, hopefully someone has information to this, and if they do, they're going to be $100,000 richer, and they should. This is uncalled for. I don't care if this was civilians or police officers. You don't just do this. It's wrong. It's nothing but an ambush, and it's nothing but attempted murder in the first degree. Next on the docket, prepare yourself, ladies and gentlemen. We have 2 very disturbing cases, and definitely go into the you just cannot make this up category. We'll meet Lori Lavani and her son, Tony. That's right. They live in Massachusetts, and the mother and son have been charged for engaging in sexual relationships with each other. We all know what the word is. It rhymes with invest. But that word will once again get us demonetized from YouTube. Well, it turns out the wife of Tony always thought that there was something weird going on because Cheryl's 63, her son is 43, their biological mother and son, and they've been in charge with that word that rhymes with invest because the wife of Tony walked in on the 2 of them engaging in sexual intercourse. The wife said, "I've always had suspicion of the 2 of them having an intimate relationship." A little weird, a little creepy, and totally against the law, for sure. When the officers arrived, the wife of Tony told the police that they caught the mother and son engaging in these sexual acts. And apparently the mother was naked and on top of Tony. Now, when questioned by the police, Tony apparently said, quote, "I don't want to talk about it. I made a mistake and I'm embarrassed enough as it is," end quote. When the officers persisted, saying that your wife walked in and saw you engaged in this act with your mother, he replied, quote, "Yes, we did have sex. It just happened," end quote. Tony also admitted that, yes, in fact, they were both naked when all this went on. When the mother, Cheryl, was asked if she was having sex with her son, she replied, quote, "Yes, we did. I was on top of my son on the couch." When asked by the police what may have led her to have sex with her son, she responded, quote, "Well, myself and my son have gotten a lot closer over the last few months, and we just had sex after we were kissing," end quote. Ladies and gentlemen, you just can't make this stuff up. But remember, these laws have been on the books for a long, long time. Everybody acts like it's something new, but I think we had all this stuff figured out a long, long time ago. Let's take a look at disturbing case number 2 today. Meet 38-year-old Daniel Wayne Rice. Now, obviously, just like everybody in our disturbing cases, they are given the presumption of innocence. However, Mr. Rice was indicted on August 27th for, that's right, bestiality. Not sure what that rhymes with, but we're taking our chances with the YouTube monetization gods. He was arrested and remains in custody on a $150,000 bond. According to the arrest affidavit, because I'm not making this stuff up, a woman allegedly found videos of Rice naked and on his knees following the family dog around the living room. She later informed the Smith County Sheriff's Office deputy that she had video evidence, and on August 11th, she delivered her phone with the video to the sheriff. The woman then told the deputy that she had a camera in the living room to watch her children while she was away. On August 5th, she saw notifications of movement on the camera, and when she returned, she saw the video of a naked Rice in the living room. This is all according to the affidavit. Then on August 12th, the deputy saw the video of Rice wearing only underwear and talking to the dog. He then apparently removed his underwear while talking to the dog. The dog ran out of the room, but Rice was seen grabbing the dog by its collar and pulling the animal to the ground. Rice apparently then participated in graphic acts that, according to the law, meet the elements for bestiality. Apparently on the video, and we don't have it, thank God, the dog could be heard whimpering and whining in the video. Rice repeatedly told the dog to shh. That's right, be quiet. That's crazy, ladies and gentlemen. But that was our second disturbing case for the day. You can't make this stuff up. I think the greater question needs to be asked is, who is this woman? Why was Mr. Rice around her? And was he ever alone with the children? That's a little scary, ladies and gentlemen. A little scary. Well, you probably, if you're not in complete shock, maybe blushing just a little bit, let's take a quick recess. It is because of these disturbing cases, ladies and gentlemen, which is why we recommend you going to CrimeTalkSearch.com and signing up for a background subscription service. It's a small fee. It's a subscription. You can cancel at any time. But when you sign up, you can search any name in the United States. That's right. And all of this is done completely anonymously. So if you think it's a little weird that the guy talks to the dog, maybe you want to see. Maybe he's got a criminal history, right? When you hit that return button, a report is generated literally while you wait, after millions of public records are searched, and you will receive a report that will include phone numbers associated with that individual, email addresses, social media sites that are associated with this particular person you're searching. And more importantly, you're going to get a criminal background search, property record search, marital record search. So if you had any doubt if maybe the gentleman that you're beginning to date or the woman that you're going to get involved with is in fact truly divorced, this is the best way and easiest way to do it. Go to CrimeTalkSearch.com, sign up, you won't be disappointed. And if you have any doubts, just remember the disturbing cases of the day. Next on the docket, our feel-good case for the day. That's right. Meet Jarrett Adams. He was wrongfully imprisoned, and now he is a criminal defense attorney and has dedicated his career to bringing justice to those who are underserved. Mr. Adams had a huge experience with the law, where he had to basically prove his own innocence after being wrongfully imprisoned for nearly a decade. Mr. Adams was born and raised in Chicago, and he graduated from high school in 1998 at the age of 17. And one night, he, along with a couple of friends, snuck out to go to a party at the University of Wisconsin in Whitewater. That night changed his life forever. 3 weeks after the party, Adams found a business card from a police officer lodged in his front door. A girl at the party had accused Adams and his 2 friends of sexual assault. Despite a witness statement that contradicted the accuser's story, Adams and his friends were charged with sexual assault. He claims that they were totally innocent and everything was untrue. Adams, 17 years old at the time, was tried as an adult. Now, while one of Adams' friends was able to afford to hire an attorney, Adams and his third co-defendant were assigned public defenders in the case. All 3 went to trial together, and the first trial ended in a mistrial. It ended in a mistrial because of testimony of our accuser dramatically changing, and the court called for a retrial. Well, Adams' friend's private attorney filed for a dismissal based on the grounds of double jeopardy, arguing the court could not try him for the same crime twice. The 2 public defenders did not. Now, during Adams' retrial, the public defender called for a no defense theory, which would not allow for any witness statements. This move backfired. They completely committed to a strategy that was illogical, and it resulted in Mr. Adams being convicted and sentenced to 28 years in a maximum security prison. Adams' co-defendant, the one with the private attorney, never spent a day in prison. The prosecutor dismissed all the charges against his co-defendants, and you would naturally expect that that would happen for him, is what he anticipated. However, they had to appeal, and 7 more years for him to dismiss the charges for a case that he did nothing wrong. The court eventually dismissed his friend's charges after police turned over an important witness statement. However, because Adams' no defense strategy did not allow for witness statements, it was not considered in his case. Adams was sentenced to 28 years in prison, and he had sort of a epiphany that would wake him up, because he thought basically everything was just going to be okay. One day, he was talking to his cellmate, who was an older white gentleman, and this man was serving 2 life sentences. And he says, "Hey, look, kid, you get up every day. You go out here and you play chess. You play basketball, and you don't act like you're innocent. Innocent people, they're in the law library." And that's what Adams recalls. And ever since that day, that was his wake-up call, and he started to get a grasp on the law. And that's where he discovered that you have to have effective assistance of counsel. Not only do you have to have it, you're required to have effective assistance of counsel. Well, in 2004, the Innocence Project took up Adams' case, and he was ultimately released. Mr. Adams did not use his lost time for no good. He went back to college, completed school, ultimately was accepted into law school, and is now a practicing attorney. What's notable in Mr. Adams' case was that he was exonerated. One of his co-defendants never had his charges dropped, while another was never convicted at all, even though all 3 men were accused of the same crime by the same accuser. It does show how oftentimes the judicial system can be somewhat arbitrary, to say the least. Hopefully the system gets it right. Obviously, we know it doesn't always, but hopefully we can make it the best system in the world. Next on the docket, our cold case of the day. And this one takes us to the streets of Phoenix, Arizona. On February 4th, 1997, a partially burned body was found in an abandoned blue Honda Accord in the area of North 24th and East Monroe Streets in Phoenix, Arizona. An empty brown vinyl purse with writing on the outside containing the name Monique was found near the body. On the body were found a watch and 2 yellow metal necklaces. Forensic scientists determined that the deceased was a 20 to 50-year-old Black African American who stood approximately 5 feet 3 inches tall and weighed about 100 pounds. She had black hair. Witnesses said the deceased was possibly a transient who had been seen in the local area before. There was some belief that she may have suffered from mental issues. The photo is an artist's interpretation of what the female may have looked like. If anyone has information about this case or other cold cases, they should contact the local authority. But as it relates to this case, contact the Phoenix Police Department and ask for Detective Stuart Summershoe at area code 602 261-8065. Ladies and gentlemen, these cases need to be solved. And although no one may have even looked for these particular individuals, maybe they didn't have any family, everyone still deserves to know who they are and what information can lead to the person responsible for their death. Next on the docket, our winner from the Dumb Criminal Contestant of the Week last week. And it was some strong competition. Every week, you can't believe what these individuals are getting themselves into. Now, it was a close call between the woman on Friday who attacked the individuals at the drive-thru window for not providing her cookie, as well as Teresa Stanley, the woman who was in the adult entertainment bookstore, naked, pleasuring herself with the adult toys. Well, guess what? Miss Stanley, you are our Dumb Criminal Contestant of the Week. And guess what we're going to do? We're going to send you a mug at no cost to you. I will find you. I will ship it to you. And when you get it, call me. Let me know. Maybe you can tell us about your entire experience in the judicial process and maybe what led to this, because I'm guessing drugs or alcohol, but you never know. Now, if you would like to be able to get a mug or other Crime Talk merchandise, simply go to the link below, go to Teespring, bam, there you go. You'll have this stuff to you shortly once you order it. Now, for our Dumb Criminal Contestant of the Day. Our Dumb Criminal Contestant of the Day is Mr. Patrick Steiner. He is 35 years old, and he was charged with an incident that took place last month at a Giant Eagle store in his home of Altoona, which is a city about 80 miles east of Pittsburgh. Now, according to the Logan Township Police Department, Steiner was inside the Giant Eagle on a Thursday afternoon when he refused to wear a mask when he was asked to do so by the store manager. According to the investigation, Mr. Steiner then threw boxes of frozen pizza at the manager and then fled the store. The victim, which is the store manager, was able to provide the police with a license plate of Steiner's car, which resulted in the traffic stop and the alleged pizza pelter arrested. Police did not indicate whether Mr. Steiner intended to purchase the pizzas or simply use them to pelt at the store manager. Needless to say, Mr. Steiner, you are a Dumb Criminal Contestant of the Week. We will be more than happy to give you the presumption of innocence, but good luck, Mr. Steiner, because it's only Monday, but you are the leader for the Dumb Criminal Contestant of the Week. We'll see if anyone can overtake you. That's all we have for you today on Crime Talk. Make sure you join us tomorrow, as well as tomorrow night at 6 p.m. Mountain Time when we go live. And we'll be answering all the questions that you have, or maybe some you haven't even thought of yet. So please join us. Have a great day. We'll see you tomorrow on Crime Talk.